30 years after failing to convince the Supreme Court of the threat posed by home video recordings, big media companies are back at it, setting their sights on Aereo as the latest threat to their financial well-being. At issue, whether Aereo is infringing on copyrights or simply providing consumers a legal service.
What this boils down to is, the difference between a public performance and a private use of a broadcast signal.
Aereo's position is that by renting an antenna to a user, they are providing customers a private broadcast. Whether that antenna is on the user's roof or 5 miles away is immaterial, Aereo says.
Debate now seems to be how far the equipment can be from you, and we think, given the importance of how all of these technologies are moving towards the cloud, it's a foregone conclusion that these things, this approach should be absolutely legal and correct and legitimate.
Broadcasters suing Aereo say it should pay for redistributing the programming the same way cable and satellite systems do. They pull in an estimated $3.3 billion a year in retransmission fees. Aereo's CEO says that revenue model is outdated.
What is happening is the entire marketplace is evolving and changing with access to alternatives, whether it's Netflix or iTunes or things like that.
Filmon.tv, a similar service, could also be affected by the Supreme Court's decision.
It is not, as many have critiqued, as being a loophole. It is working within the scope of the law. Should Aereo win, then it is a major win for the consumer.
The court's ruling could also have a huge impact on other forms of communication, especially in the rapidly evolving world of cloud computing, where analysts say many existing platforms do essentially the same thing as Aereo, giving users access to a vast network that often consists of copyrighted information. Matt Friedman, Associated Press.